Today's video, we're gonna go over to, basically how to get a new trial. This is gonna be brief, but and this is the law in Florida, so every state will be a little different, but in most cases it will be similar. Your Fed will be a little different too, but this will focus on Florida. And again, we're gonna be talking about how to get a new trial. So let's say you've been convicted, you or your loved one is in prison now, and you're trying to get a new trial. So you got a couple of things we're going to cover here. One, a new trial. So on the newly discovered evidence, you can come back in a new trial, but there are a couple of points that you want to think about if you're going to, attempt this. One, let me start off here. So after you get convicted, you basically, if you have an appeal, a direct appeal, after that process, or if you don't do a direct appeal, once you are convicted, you have it's a 2-year period to file what they call a 3.850, which is post-conviction relief. That's the vehicle that you would use and have 2 years to file an appeal. Now, again, that has a 2-year limit. Your newly discovered evidence does not have any limit, but here are some of the key points on newly discovered evidence. And make sure you know these things. To either talk to a lawyer or make sure you know what you're doing before you file this. I know a lot of people go pro se. That means the inmate, prisoner files the paperwork itself. A lot of times you can't afford a lawyer stuff, but just all I'm recommending is do your time, do your research. If you have to do it yourself, there's a lot involved, and try not to get, I see so many people, inmates, guys, that get so locked in your case, you want to come home. I get it, but you gotta meet the rules. You know what I mean? So for instance, on the newly discovered evidence, yes, you can bring that up at any time, but it has to be evidence that was not or could not have been known at the time of the trial. So for instance, if it was, let's just say you had a witness that could say you were somewhere else. Now, let's just say during the trial, you knew about this witness, you knew about their statement, you just decided for whatever reason, you and your lawyer decided not to introduce that evidence at the time of the trial. They will not let you come back there. They're going to deny your appeal if you come back 4 years later and say, hey, I want to use this witness. They're going to say, well, no, you knew about that at the time of the trial, so you can't do that. So that's your first thing. It has to be some type of evidence that you did not know about or could not have known about at the time of the trial. That's one. That's like your first hurdle. Second hurdle, you got like what they call a Strickland test. Basically, to keep it real simple, it's a couple more hurdles. There's a 2-prong test in Strickland. First is as far as was it an error. So you have to show an error occurred. For instance, let's say that the prosecutor in the trial said something prejudiced that they shouldn't have said. For instance, let's say you wouldn't take in the stand, and at some point the prosecutor said, well, the defendant's already been convicted 8 times, and said that wasn't going to come out in trial, you wasn't going to take the stand, the prosecutor couldn't say it. So you got an error there. Now the second part of Strickland, or the second part of the process, okay, you show an error. That don't mean it get overturned or reversed for a new trial. I'll just show the error. You got to show that second part. And that second part is that it would have most likely changed the outcome of the trial. Now that's the big hard hurdle right there. And let me give you an example of that. Let's say you got four witnesses that say, hey, the defendant beat up this person. Let's just say Irvin beat up Tasha. You got 4 witnesses saying that. And then I try and come back with, on newly discovered evidence, I come back with another one. Well, this way I got to find a 5th witness, and that witness say, no, that he did not beat up Tasha. He beat up somebody else. That ain't going to get you over the hurdle of most likely would have changed the outcome of the trial, because you still got 4 witnesses saying that you did it, and you just got 1 saying that you didn't. So that ain't gonna get you past that hurdle 9 times out of 10, most likely. So an example of what would get you past that hurdle, say you got a witness against you, said, hey, Irvin sold me X amount of drugs. Okay, now say that witness comes back in the future and say, you know what, prosecutors pressured me. I was just scared. For whatever reason, I lied. That's not what happened. Now, that would have changed most likely the outcome of the trial. If you only got 1 witness and that witness is changing their statement, their story, then yes, you met both prongs. Error occurred, that the witness lied or whatever, and that's the only witness that get me, and now she's saying that didn't happen. Bam. Now that's a new trial. and that's how you get a new trial. And once you get a new, so, and the main point of getting a new trial, so a lot of guys, so say you went to trial, two things you can do as far as getting a new trial. One, a lot of people, let's say you went to trial and you got sentenced to 15 years, they give you more time because you go to trial. You might have been offered 5 years, but you went to trial and got 15. So again, when you come back now, if you can come back on appeal, when you get back to the trial state, okay, they might offer you that 5 again. You've already been in prison for 4 years, so you're basically done. You'll accept the 5 this time. Don't mean they have to offer it to you, but a lot of times they will. So that's one reason of, going back, trying to get a new trial, even if you don't intend to go back to trial, just to get back to that pre-trial status where you can bargain again. If you do plan on going back to trial, again, with that new evidence that you bring in the trial, hopefully you would be, if you're not a crazy wacko, some people do deserve to be in prison, but if you're not a crazy wacko and you're able to present that new evidence, you may be able to succeed in trial. So, but that's the thing as far as trial. Again, comment, let me know. I'll try and answer any questions you have. But that's the vehicle. You have several types of appeals. You have, after you go to trial, your first major appeal is direct appeal. Direct appeal really, they only allow you to bring up errors that occurred in the trial. So that's when you see the lawyer like objection. I object, Your Honor, hearsay or something like that. All those objections from the trial, they're brought up on direct appeal, which is your best chance. They really look at direct appeals pretty good. If you're in like the second DCA, Tampa, St. Petersburg goes to the second District Court of Appeals. They're pretty liberal, pretty good court. I was actually reversed myself. My trial was overturned and reversed in the second DCA. So I got a little experience with this myself. You have another called 3.850. That's your post-conviction relief. I spoke about that a little earlier. That's, after you convicted or after, let's say you went to the direct appeal from the second DCA and you was denied, now you can come back on 3.850. And that's when you can bring up other things, not just things that went wrong in the trial that your lawyer objected to. You can bring up, hey, my lawyer should have objected to this, what they call ineffective counsel. So my lawyer should have done this, but didn't. And that's why I'm coming back on what they call ineffective counsel on 3.850. So a lot there. I just wanted to go over a few of those things and let you know though, but do not get so intertwined either in your loved one's case or if you're in prison yourself. You still got to meet these standards. And again, don't get, I found somebody that says that I didn't sell the person drugs, or they said that I wasn't even there that night, I was over here. That's irrelevant if you got 3 other people still saying you was there. That's not going to get your conviction overturned. You know what I mean? So just keep it in reality and think that you still got to meet these standards and laws, even though you want to get out, you want to make. Don't, because you just want it so bad, file some stuff. And because I've seen a lot of people get barred from the courts too. So filing just foolishness or whatever can't get you barred from the court. So be careful with that. And until next time, you guys, please keep liking these videos, commenting on them, and we're going to try and push out more content. And I appreciate everybody who has subscribed to the channel. Thank you.